faith and Indian Constitution in the modern India, we are very proud to announce a very impressive rostrum of speakers with us today. Is Vikramjit Banerjee, sir. He is the first ever graduate from a national law university to be appointed as the Additional Solicitor General. A graduate from the batch of 1997 from NLS Bangalore, sir completed his LLM from the University of Leicester in the year 2000 and was appointed as the ASG for the Supreme Court in February 2018. Sir has also served as Nagaland's Advocate General, appointed in the year June 2015, and was designated as Senior Advocate in the Guwahati High Court in December 2016. We are very glad to have you with us, sir. Our second panelist is the illustrious Sai Deepak, sir, who is an engineer turned litigator. Sir did his BE in Mechanical Engineering from Anna University and obtained a degree in law from IIT Kharagpur in 2009. Sir has represented two women's groups, Chetna and People for Dharma, in the controversial Sabarimala Case and caught the attention of the nation through his celibacy argument, earning him the moniker, the lawyer for Lord Ayyappa. Sir has over 9 years of experience in the Delhi High Court and possesses expertise in civil and commercial litigation. Sir is also founder of the legal blog, The Demanding Mistress, and a regular contributor to Swaraj, India Facts, and the Times of Israel. An associate partner at Sai Krishna and Associates till the year 2016, Sir founded the Law Chambers of Sai Deepak in June 2016 and also practices as an arguing counsel. Sir has also been an advisor on an honorary basis to the Ministry of Commerce on implementation of the National IPR policy. I must also highlight Sir's modesty. When we presented him the draft introduction, he very modestly crossed out all the superlatives that we had used for him in the draft introduction. Sir, thank you so much for gracing this occasion with your presence. Our third panelist for this session is our very own professor, Professor V.K. Dixit, sir, who has had a very impressive teaching career of 50 years that began in the year 1969. Sir has taught several subjects that include jurisprudence, law and society, the sociology of law, constitutional law, administrative law, competition law, labor law, research methodology, etc. Sir has finished his LLM from the Aligarh Muslim University and pursued his PhD from the University of Delhi. After his superannuation from the University of Delhi, Sir has worked with several institutions of national repute, which include NLIU, the Judicial Academy Bhopal, Indian Law Institute Delhi, and the University of Warwick, UK. Having been Sir's student in the competition law course last semester, I must express that, Sir, we are very glad and very lucky to have you as one of our guiding lights for this symposium. I request Professor V.K. Dixit, sir, to present the embossed silver coins of the university to both of our guests. Okay. So the speakers are free to sort of address the audience from their desks, and they're also free to come here and interact with all of you. After their initial remarks, we'll open the panel discussion for questions and answers from members of the audience. Thank you.
Sitting beside Sai is always a revelation, because Sai Deepak is a person who is deeply knowledgeable, and Sai Deepak is also in many ways a person who takes a lot of the knowledge which he has into court and tests them. Sai Deepak is also has a large amount of knowledge on law and faith. And this faith, law and faith, this knowledge which he has on law and faith, he has not necessarily keeps it to himself, but goes and argues these arguments in court. As all of you know, he's very much in vogue these days. A lot of people follow him. He is, in many ways, a very, very prominent person amongst the new generation of lawyers. So I'm always very, very circumspect when I address in Sai Deepak's presence because of both of his knowledge as well as his ability to very, very articulately argue his point of view. Now, when I was asked to address this question, I must give you a context of it. I studied law and religion, and I'm saying explicitly law and religion, at the University of Leicester, when it wasn't such a fashionable thing to do. Because before all these huge questions of law and religion were actually came into focus. Because I have always felt that religion has a huge impact, faith has a huge impact on law. And that has been completely disregarded. That has never been paid attention to. So when I decided to do my master's in the subject of law and religion at the University of Leicester, I think there were 2 other people who attended the class, and both of them left in the middle of the class because they had possibly better things to do. So today I know that it's a huge issue that we are grappling with all the time, and a huge issue which is the question of our age. So when I want to address you on this, and that's where the boring parts comes in, I will contextualize it. I am not too much of a person who goes by the letter of what the Supreme Court has pronounced, because the Supreme Court pronounces various different things at various different times depending on what, I'm using a strong word, being position which I hold, being what is the flavor of the season. I won't address that question, but I'll address you by first contextualizing where I come from. It is important to understand this entire question of the conflict between faith and the Constitution by sort of exploring what is the history of law and faith and how have they fit in. So I'll just try to summarize it. This is the boring part of it because a lot of it, I don't know whether you've been taught or whether you would even find it remotely interesting. But this is extremely important, is because today our Constitution is a product, as was discussed, of 1935 Act, with fundamental rights added to that, but is a product of a civilization, of a cultural background, which is very different from the society that we live in and the cultural parameters that we have been used to, that we have survived for thousands of years. So to understand this conflict that we face today, it is also important for us to understand where the constitutional background of where we come from, where does that come from? So I will try to sort of give you a comparative idea right at the beginning as to what were the 2 broader ways how the state has handled, conceived of, how a state conceived faith. The first is the way the old faiths have handled faith. And the old faiths is, I take off the old faiths is pre-Judeo-Christian faith, because in the history of world religions, it is Judaism, Reform Judaism, Christianity and Islam follow subsequently in a single line with their differences. But in many ways, the large contours of the Indian civilization as we see it today inherits from a background which is even pre-Christian, much more common to pre-Christian faith, pre-Christian relations between law and state, which existed. Now, all of us wouldn't have heard of this, because it's not studied. But the fact is, the huge Roman Empire that which all the law, Western law, traces its roots from, was for a very long period of time pre-Christian. So, the entire Athens, when you speak of, the law was pre-Christian. The entire Zoroastrian, the Persian Empire of Cyrus the Great was pre-Islam. So there was a conception, and China, India, the rules, the laws have still survived. Now the entire conception of the old religions, and I'm talking about old religions in terms of pre-Christian faith in Europe, dealt with law in a very different manner. It did not deal with people and communities as specific legal systems. It dealt with a large conception believing that law was natural, came from the people, could be discovered, and has to be interpreted within the people. So it dealt with faith more as a part of society, because faith, society and law was largely inseparable. Anyone who studies Indian law, Indian civilizational law, for want of a better word, which is used as Hindu law, would tell you that it was interpreted as a network of norms which the interpreters of law interpreted and was implemented through either the king or through the society itself. So in that case, you did have multiplicity of faiths. It's not that you did not have multiplicity of faith, you had multiplicity of faiths. People followed Bauddha Dharma at that point of time, which people followed Sanatana Dharma at that point of time, Jain Dharma, and there were Charvaks, there were a large number of people who followed different kinds of faith. But the way to handle it was more like what Ashoka did. And I'll come back to this entire question of why I would contrast Ashoka and Constantine, how they both addressed the same question. And the other sort of posited against it is the way which first started during Christianity, when Constantine converted into Christianity, was to try to ensure that there is uniformity within the people. So therefore you have uniform laws, you have uniform faith maybe. While Ashoka talked about that you have to find unity in diversity, Constantine's interpretation was you found diversity in unity. And this is the essential conflict which we are increasingly facing today because of two different conceptions of how to envisage law and faith in modern world, in today's state. Now, what is Constantine? Ashoka we are all aware of because that's what we have grown up on, we've read in history books. And this is the essential difference between law and Ashoka and Constantine. Both of them, in different parts, in different times in history, were faced with the same question. You have a very diverse empire, with diverse people having very diverse faiths. And you have an increasingly bureaucratic, powerful empire growing. How do you handle that? While Ashoka said, you've seen the edicts of Ashoka saying that everybody follow their own rules, but I believe that there should be a dharma which everybody should follow. And you try to encourage people to follow that dharma and put edicts and... But on the other hand, the Constantine view at that point of time was you had a diverse people speaking diverse, having diverse religions, or faiths at that point of time. Religion is a new word. You make them come to a unity. And in that portion, maybe they have their own diverse interpretations of it, but let that be only interpretations of it. So there are two ways, broad ways where, you know, these things have been dealt with. Now, when it comes to India, we have a constitution. We have a constitution which deals with faith in a way which inherits its inheritance from, want of a better word, Roman law. Because all of us, again, this is something which all of you should read, and that is why I said this is the difficult part, but we should all be interested in it. Because the conception of a constitution as we see it today comes from Roman law, comes from the Code of Justinian, which says everybody in this great diverse Roman Empire that we have should be governed by this common code. All people should be governed by this common code. Which then goes to the German constitutionalism and then becomes accepted as constitution through the American Constitution and then the French Constitution after the French Revolution. But it's largely, the background is Roman law. In India, you did not have a constitution. It does not mean that people were not governed for 5,000 years. People were governed, but they did not conceive of a fundamental unitary law which governs everyone. And this is the essential conflict which I think is unique to India. Because even, I think in the 1600s, 15 and 1600s, which was, I think, an epoch-making portion of history across the world, when India was governed by the Mughal government system, this diversity of the uniqueness of India was recognized. If you look at the compromise which was made at the time of Akbar, because Akbar was the person who formed the basis of the Mughal state. It is he who put the basis of the Mughal state, because his father was there for a very short period of time. His grandfather was father in and out of India. His grandfather was there for barely 5 years. So it was Akbar, from Akbar onwards actually the Mughal Empire actually starts. And he comes with this compromise. And this is the compromise which lasts actually till the British comes over. And again, this is something which we should all study, which we don't. Is he said that every community is going to be governed in terms of the millet system, which is an old Turco-Iranian word, whereby every community is going to be governed by their own laws, and these laws are going to be inviolable. And the state largely is going to stay out of religion. But the state is also will be spiritual in many ways. And in his own way, he tried to find out his own spiritual halfway house between different religions of the world. But that's what he sort of wanted. That is, so this compromise was at the basis of the Mughal state. Now, no doubt, towards the end of the Mughal state, this consensus frayed. This consensus frayed because that was during the entire world, when the context of what Aurangzeb happened is during the entire world, when the state became more invasive of religion, is because it was happening all over the world. It was happening in Persia, it was happening in Europe. You look at the date line, you will see that it's not unusual. This is exactly what was at the same time as Aurangzeb existed. There were issues of similar nature what was happening in Europe, or the same issues were happening in Persia. So there was an attempt to have a unitary state, unitary faith, but that didn't work. Now, when the British came, again, it's very important, when the British came to India, they, in the very beginning, when they first came, East India Company, there was a large amount of attempt to change Indian religion. And today, which cannot be disregarded and needs to be spoken, is there was also large amounts of attempted conversion. This led to 1857. And you all know what happened in 1857. The British, at that point of time, came to the idea that the reason why all this happened is because we tried to interfere in people's faith. So in 1858, and this is the beginning of what we today talk about Indian secularism, and that's why I'm saying that you have to study constitutionalism in a context. In 1858, in Queen Victoria's declaration, one of the prominent articles in Queen Victoria's declaration was that we will stay out of religion and we will treat all faiths equally. And it is from that day when the British courts in India, before that they strongly interfered in local religion. From that day onwards, the British courts decide to keep away from religion, saying that it is your religion, you understand the rationality of your religion. Now, rationality of your religion will be dictated by yourself, by the community which holds it. So it combines the millet system, which says one community will hold its own values, its own faith, and says that's inviolable as long as you don't break the law. So in cases of sati, in cases of something which we think is abhorrent, then we will interfere, otherwise we will stay away. Now, the Indian Constitution, to that extent, is a break. Because the Indian Constitution, again, it needs to be contextualized. The word secularism is attempted to be introduced in the first draft of the Indian Constitution when it first comes. And all of us know this, but I'm just reminding you that it is rejected. It is, the word secularism in the Constitution was rejected 4 times. It was attempted to be introduced in the Constitution 4 times. It was rejected 4 times. But in the end, but I would say this also to be very, very fair, the consensus, even from Shama Prasad Mukherjee, on a number of occasions, was that we are going to have a secular state. In fact, the argument was it is so implicit in the Constitution that you don't need to make it explicit. So that was taken to be a given, but the word secularism was rejected 4 times, and the last intervention was by Ambedkar. When Baba Sahib Ambedkar, when it was number of times, he finally stood up and said, sorry, we don't want to burden the future Constitution with the values which we think are important today. So, as again we all know that the Constitution was changed by the 42nd Amendment and secularism was brought in specifically. And I think the issue which is today we are grappling with so explicitly, both in the Triple Talaq judgment and in the Sabarimala judgment, the genesis happens from, very specifically, from the amendment. Because otherwise what we had decided, the large consensus was given. You now decided to make it explicitly a part of the constitutional system. And when you inserted the word secular, you brought in conceptions of Western conceptions of religion, Western conceptions of law, inside the governance of faith. While the large consensus including from the time of the British, is that the state stayed away from faith unless it came to law and order problems, or unless it became so abhorrent that the state had to interfere. Now, I will, in the end, sort of come to the crux of what I want to say. Lately the Supreme Court has been confronted by this entire question. And that's been a long time coming, and it's now upon the Supreme Court. Supreme Court, I will take, has adopted 2 lines of arguments. One is the Triple Talaq argument, and the one is the Sabarimala argument. And I would say I distinguish both. In the Triple Talaq argument, it broadly, even though, however, you may say that it was invasive, But the Triple Talaq argument, it broadly accepted that the faith should be treated on its own terms. Because if you remember Kurian Joseph's famous line in Triple Talaq argument, what is bad in theology cannot be good in law. And you would see Rohinton Nariman making that, Justice Rohinton Nariman, making that argument that because it was part of the, because it was Triple Talaq could be governed by the Sharia Act, and so therefore that was law and therefore we could amend it. It explicitly or implicitly stayed away from pronouncing whether tenets of faith went against the Constitution or not. This, and I say this, and this is a very dangerous line, which I feel is a dangerous line. The Supreme Court has held what it has, which it changes in Sabarimala. In Sabarimala, there are two conceptions which the Supreme Court formulates, which I have great differences with. But then my personal differences. Now, I'm not speaking as the Additional Solicitor General of India. I make it very explicitly clear. I have two differences, and I'm talking about it in a clearly academic perspective. One is it comes up with the idea of a transformative constitution, which is the day the constitution comes, all your history and your background and your civilizational experiences go out of the window. You start with a tabula rasa. And the other is constitutional morality, which was discussed. Now, why is constitutional morality important under this context? Short, because you have the right to religion under Article 25, and the exception to right to, which says that your right to protect, to practice and propagate your religion, you have the right. The exception to that, there are a large number of exceptions, public order. One of the grounds is morality. Now, morality is usually understood to be public morality, like sati was against public morals. So if you took an interpretation, possibly acceptable. But the court said no. Morality is not public morality, or what is accepted morality would mean what is abhorrent to the majority morals of the society. Morality is constitutional morality, which means the morality as interpreted to be against the Constitution by the Constitutional Court. Which means that from now onwards, you have devised a conception of morality which may have nothing to or have no connection with the general number of people in society, but what would be construed as constitutional morality amongst people on the bench, because that's the final arbiter of who decides what is constitutional morality and what is not. And I personally think it is a very dangerous path to go under. Because tomorrow I see increasingly, and I see this, increasingly your faith and culture will be attacked on the ground by groups of people, well-intentioned, I have no doubt about the intention, on grounds of being violative of constitutional morality. And who decides this constitutional morality? Largely, this constitutional morality comes from a milieu. I am saying because the judges reflect us, from people like us. But this vast country that we exist in are not filled with people like us. You know, I've been across, up and down this country, very diverse, and people are not like us. We have the benefit of this wonderful education. We have the benefit of arguing before the Supreme Court. we have the benefit of understanding English, we have the benefit of so many other things. We are very privileged. And we have our conceptions of the world which is keyed into Harvard, to the West, to Oxford, to Cambridge, which is very different from where the rest of the world, rest of India views the law, views morality. And having an idea like constitutional morality almost means that the state, through the judiciary, has the right to impose what it conceives as moral upon the rest of the people. What could be, to my mind, what could be more oppressive than that? Now, I personally agree that if there is one part of the judgment in Sabarimala I agree with, is what is the dissent of Justice Malhotra. When Justice Malhotra said that the essence of constitutionalism is that you have multiplicity of faiths and you respect all of them. I think what she talks about is cultural constitutionalism. And I am a person who contributes and who believes more in cultural constitutionalism than transformative constitutionalism. In the history of India, I can assure you, large groups of people, not every, but large elites have always thought that they want to transform India. But it hasn't worked. One more in modernist guise, I don't think will serve its purpose. What do I foresee in the future? And I'll just end off by saying this. I foresee this conflict growing. Because we live in an interconnected world, we live in a world where people are becoming more and more modern and, dare I say, westernized, where our centers of culture are moving away from Indian universities like the Banaras Hindu University, the Aligarh Muslim University, and moving to Harvard, to Cambridge, to these wonderful institutions, no doubt, but completely conceived in a different cultural background. And the more you impose the values, the more pushback you will get. The harder the pushback. And in fact, in conclusion, I don't think that the conflict which you see in Sabarimala is only an indicator. There will be much, much more, there will be more, and there are more coming. And I can see them happening right before me, but I won't comment on them because I have this job. This is not the beginning of the end. This is just, as Churchill said, the end of the beginning. Thank you.
Thank you for bringing out the historical and philosophical underpinnings of religion in the Constitution. I'd now like to welcome Professor V.K. Dixit, sir, to express his perspective on the topic Faith and Indian Constitution.
Well, thank you very much. My co-columnist and the distinguished gathering here. The subject on which I am required to speak today, Faith and Constitution. Before speaking further, I want to make some preliminary observations. Frankly speaking, I must confess, I have little faith in faith. Of course, I have tremendous faith in the Constitution of India. And secondly, I am of the considered opinion that the Constitution of India is less of a legal document and more of a social document, because it regulates our lives, the life of the nation, and precisely for this reason, it is the most important document in the life of the people of modern India. As India is a multi-religious society, it is all the more reason why the Constitution of India must be considered to be a supreme document. Because if it is not considered to be the supreme document, then every religion will claim supremacy, which shall be disastrous for the peace in the country. And more importantly, it is likely to become a tyranny by the majority over the minority. So precisely for this reason, I have tremendous faith in the supremacy of the Constitution. The declared policy of the Constitution is that Indian Constitution establishes the ideology of secularism. Secularism may exist at several levels: normative level, cultural and institutional levels, as well as on behavioral level. At behavioral level, in India it is the weakest, and at the normative level it is the strongest. But normative level is the beginning or the starting point, and therefore it is also very important for me. Unfortunately, in this country, neither the courts nor the people have been able to understand as to what ought to be the definition of the secularism in this country. Whether it means separation between the state and the church, or it means, as Gandhi believed, that all religions must have equal respect. And for Gandhi, there was never a separation between the religion and the state, in the sense that he very, very successfully and honestly was able to use religion in the politics. And perhaps he was the only person in the history of the world who so honestly and successfully was able to use religion in politics without offending any particular faith, primarily for the reason that Hinduism was so extensive according to him that it was compatible with all the faiths in the world. There was no conflict between his Hinduism, I'm not talking of the Hinduism of the present day, but his Hinduism and other faiths. Now we are coming to the approach of the courts with regard to faith. Particularly, I am of the opinion that almost all the religions of the world are grounded in the ideology of the patriarchy. And precisely for this reason, one of the worst victims of religion, without any exception, is the status of women. Every religion, to a greater extent Hinduism, and to a lesser extent Islam and Christianity, have victimized women on grounds of religion. So therefore, today I intend to discuss primarily religion as it discriminated against women. As far as religious specificities are concerned, there are several approaches to judge the constitutionality of religious specificities. Some judges believe that when it comes to the core or practices of religion, they cannot be discussed on the touchstone of fundamental rights. This ideology was given under a special circumstance. Particularly, it was done by the Bombay High Court in Narsuakamali's case, where the legislature of Bombay passed an enactment prohibiting polygamy among the Hindus. So the argument given before the court was a very, very curious argument and a mischievous argument, I will say. That is, how Hindus can be forced to be polygamous when Muslims are not. It is just like the argument that how can you punish me for theft if there are other thieves in this society also. It was projected as if polygamy is a desirable practice. And because it is allowed in the case of Muslims, therefore it should be allowed in the case of Hindus. What was the difficulty if a social reform is introduced among Hindus and not among Muslims? The Muslims have a ground to complain, but Hindus should not have any ground to complain. And therefore, precisely for this reason, the court observed in this case that this particular legislation shall not be discussed or its validity cannot be understood with reference to the rights. But I think this decision should be confined to its peculiar facts. Because I am of the opinion that no practice, whether it is the practice of the majority or even if it is the core of religion or whatever it is, no ideology, no practice can be allowed to exist if it violates the provisions of the fundamental provisions of the Constitution and the constitutional morality. Then there are other approaches, that is the core of religion or essentials of religions are protected. They are protected on two specific grounds, on the grounds of scriptures and on grounds of practice of the followers of that religion. And there is a difference between both of them. Then, if religious practices are violative of the fundamental rights, again, they cannot be allowed to exist. Now, unfortunately, whenever religious practices are challenged, very, very strange arguments have been given. Number one, the argument was given that because it is a part of our cultural specificity, therefore it must be allowed to stand. Number two, the practice is practice of a minority of the society, and therefore to disallow this practice will amount to tyranny by the majority over the minority, as was done in Sabarimala Case. Number three, our law is made by God and therefore it cannot be challenged by any human being. Article 25 protects our practices, including religious practices. And last but not least, the Supreme Court does not have any jurisdiction. It was said famously by L.K. Avani, and he famously said Supreme Court cannot decide whether Ram was born here or there. Similarly, when this Triple Talaq case was there, All India Muslim Personal Board, some functionary said, Supreme Court does not have any jurisdiction. So, the interesting thing is, even the jurisdiction of the court is being denied in order to protect certain religious practices. Now, first of all, we will take the case of this Triple Talaq. This is the first case where Supreme Court was extensively defensive, which it should not have been. In the sense that in the history of the modern Indian legal system, it was the first case where the bench of the court was constituted on grounds of religion. It has never happened in the history of India, of modern India, that the bench has been constituted on grounds of religion. And it was done by the court because the court was extensively defensive. So, two judges followed, declared that the practice of Triple Talaq is constitutionally valid because it is the practice of the followers of Sunni Islam. Then two of the judges, Justice Lalit and Justice Nariman, declared it unconstitutional on grounds it violates fundamental rights. And Justice Joseph Korean on grounds that it is violative of the provisions of the Holy Quran. And therefore it was declared to be unconstitutional. But the more important is the case of Sabarimala. It generated too much of heat. And it was the first time when against the judgment of the Supreme Court, ordinary citizens did not protest, but the members of the ruling party protested against. And perhaps it was an extension of the ongoing conflict between judiciary and the ruling party. It commenced with the declaration of unconstitutionality of the judicial accountability system, etc. It is long. It is an ongoing fight because I always believe that whenever the central government is weak, judiciary tends to be stronger, and when central government is strong, judiciary tends to be weak. And because after 2014, central government has become weak and strong after a long period, therefore they are asserting. But the Supreme Court does not want to give up its powers. Now I have serious objections. I tend to disagree with one of my panelists. I am of the considered opinion that I am unable to agree with the opinion of Justice Banerjee because of various reasons, and more important are non-legal reasonings. Not legal reasoning so much, but non-legal reasonings. Well, unfortunately, all religions, without any exception, have tried to discriminate against women on one pretext or the other. And one of the pretexts is menstruation. It is declared by almost all religions that during the period of menstruation, women become impure and they are not allowed to do certain religious practices. My argument is, who is not impure? Every one of us carry impurities in our body in the form of excreta and urine. If we can perform religious practices, why the women cannot? Simply because of menstruation. And another strange thing is, what exactly is the reason of menstruation? it is an important means of reproductive process. So the product is acceptable to you, it is welcome, but the process is not. When a son is born, he is welcome. But the woman, because of local blood, becomes impure. Menstrual blood becomes impure. What exactly nonsense is this? The reason is not impurity. The reason is patriarchal society try to find out pretext to humiliate women, that you are impure. That exactly is the reason. Then in case of Sabarimala, it is plain that Lord Ayyappa is a celibate, particularly the deity in that particular temple. And I am of the opinion, the followers, not only insulting themselves, but they are also insulting their Lord Ayyappa also. Why? Women between 10 to 50 are debarred from entering into the temple. That is, women who are of productive age or potential productive age. My humble submission is that if somebody is a real celibate, he cannot be swayed merely on the side of a woman. What type of this celibacy means? High degree of discipline. If you are real celibate, then even if a woman comes into your presence, you must not be swayed. And for Lord Ayyappa, all the women are just like his daughters. Is there any decent person who will have the feeling of lust when he sees his own daughter? So what they are doing? I remember a very interesting story which long ago I read in a magazine. It is a mythical story that there were 3 rishis who were doing some tapasya. So the Simhasana of Indra was swayed and he thought that these persons will occupy mine. How to deviate them? He invited them and wanted to disturb their celibacy. So he ordered his apsaras to perform dances, and all the 3 were invited to watch the dance. So when the dance was going on, one of them said, "What this obscenity is, stop it. I am going out." Indra said, "He has lost himself to lust. So he is over." The other 2 said, "No, continue with it. We are enjoying." Then these apsaras removed their clothes. Then the second one said, "Oh, what obscenity is this? Stop this, I am going out." Indra said, "He has succumbed to lust." The third one was real celibate. He said, "Oh, I am enjoying. You have removed your clothes, now you remove your skin also. I want to see what is beneath this skin." Then Indra says, he is the real celibate, because he is trying to pierce through the skin of these women. So my point is simply this: a real celibate will not be swayed merely by the sight of women. If he is, that means he is a pretender. So here, in this case, my opinion is that it is an insult to Lord also, by the followers. The second important thing is that if this argument of the cultural practices or religious practices of a particular denomination are sacrosanct, then it may lead to disastrous results. it is quite possible tomorrow a person may claim that I want to revive sati because it is my cultural practice. I want to revive the practice of female infanticide. This is my cultural practice. I want to revive the practice of religious prostitution in the form of Devdasi because this is my cultural practice. So cultural practices cannot be allowed to stand if they violate the rights of women or any other section of the society. So know you very well that decision was delivered by the court that women between these two age groups would be allowed to enter. But simply because there was a stiff resistance by the followers of Lord Ayyappa in the beginning does not determine for the simple reason that ultimately this resistance will die out. When in 1955 and 56 Hindu Reform Acts were passed, there was a stiff opposition, but now we have accepted them. So in course of time, these practices will die their natural deaths. Then one more aspect I want to discuss, which also touches faith or religious freedom. It is about homosexuality. Because as far as homosexuality is concerned, there are two ideologies. One is scientific evidence that these persons are not perverts, but they have different sexual orientation. The other is religious belief. Whatever we may say, right from the early childhood, we are exposed to religious teachings. And every religion says that homosexuals are sinners. And there was a reason to it. Because these religions have their origin in either classical times or in medieval periods. I myself have studied certain data from the pre-modern period, and I came to the conclusion that in the pre-modern period, it was very, time is over, within 5 minutes. In pre-modern times particularly, it was very difficult to maintain the population. Every 5 years, 30 to 40% of the population would be wiped out because of cholera, because of plague, because of famine, because of floods, and because of child mortality, and the death of women during childbirth. So for them, every sexual intercourse which is not reproductive was a meaningless sexual activity. So there was too much emphasis on sex which results in reproduction. But today's situation has become different. And therefore, when the Delhi High Court decided this case, it was decided on the basis of scientific evidence. But I have not been able to understand the judgment delivered by Justice Singhvi and Justice Mukherjee. It was a very strange judgment. It was decided on the basis of presumption of constitutionality. Every law is presumed to be constitutional unless it is declared unconstitutional. So it was a very strange judgment. But fortunately, the judgment was corrected, or the decision was corrected in this better case, that is another age Singh case. Of course, some more cases have to be done. I will not discuss, I will stop here, and thank you very much.
Thank you for the very fresh and independent perspectives on women and homosexuality related issues, and for adding those dimensions to the current debate on faith and religion. May I now request our third panelist, Sai Deepak sir, to please express his views on the topic.
Thank you for this invitation for this wonderful topic, which I think is extremely relevant, and its relevance is only going to be proven more with time. There is a mistake in my nameplate. I am not a senior lawyer. The Advocates Act recognizes only advocate and senior advocate. I am not a senior advocate yet. I am a lawyer who is an advocate. So, you are a lawyer nevertheless? Yes, I am a lawyer nevertheless. I am not a senior lawyer. 10 years is not exactly a senior, and particularly when I have somebody like me.
You are not, but you are senior.
Okay. It's very difficult to argue with him, that much I realize. I wish I was a student of your class, sir, because I believe that it's going to be, or it is perhaps a very colorful experience to be in your class with the kind of examples and illustrations that you come out with. I think I would have had lesser reasons to bunk classes in law school. I had almost 50% borderline attendance, and I was almost debarred in my 5th semester. I was almost about to be rusticated, and then there was a disciplinary committee. So all that happened. So, anyways, you know, the one thing that I realized is, before I proceed to the topic, I'm not bragging. There's a talk that I've given on the same topic, Faith versus State, on the 30th of December 2018. And this is available on YouTube. This was delivered in Mumbai. So whatever I present now will be perhaps a capsule version of what was already discussed there. And in large parts, I will also be responding to what Professor Dixit has mentioned, because I'm very, very grateful to the organizers for giving me an opportunity to speak after him. So I'll use this opportunity to the hilt. If the Constitution is a social document, why are you harping on legal reasoning? Don't. Either say it's a legal document or it's not. If it's a social document, then do not find fault with the reasoning for being non-legal reasoning, because then the reasoning can be social in nature. But if you choose to give it the quality of a legal document, then stick to the rules of interpretation that apply to constitutional law. Or treat it as a document with a dual quality. It is socio-legal in nature. Which means it is a legal document which has social implications, but has to nevertheless comply with the rules of interpretation of a legal document. That is something that you have to be clear about. You can't shift the goalpost as and when it's convenient to you, because that is intellectual dishonesty. That can't happen. Decide the rules of the game, tell me what are the ground rules, and we'll play according to it. You can't keep making the rules as you go along. So that's point number one. Point number two is, you know, in this day and age, it's very, very easy to skew or bias a discussion by just throwing in a few words. Equality, gender justice, patriarchy, Brahmanism, everything. Throw it all in one basket and you have an explosive mixture that puts the other side on the defensive. That's what happens. You immediately skew the mindset of the audience, and then they realize, what do I do now? Oh, I'm on the defensive. Now I'm going to treat this audience as an adult audience. I'm assuming all of you are above 18. And all of you believe in free speech, right? Fantastic. Then I'll use my free speech to the end. Okay. So I hope you don't take offense, and even if you take offense, you're welcome to take offense in the spirit of free speech. Okay? So, whenever the concept of equality is touted, and it is presented as an argument, and it is presented as the ideal, or as the goal that is to be achieved, remember this, and I say this with a lot of respect, and I say this with a lot of candor and responsibility, that it commits an intellectual fraud of closing your eyes to every distinction possible, and every difference possible, and every nuance possible in logic, in reason, in science, in biology, completely out of the window. What it does is it tries to pull all the 5 fingers together and say, I want to treat you equally. The thumb will not perform the role of a thumb anymore, and the little finger will not perform the role of a little finger anymore, because both of them are equal. That is effectively the consequence of the argument of equality. Remember this, my position is simply this. the context of a situation and the requirement of a situation decides whether the distinction is relevant or not. Which means, if it is a question of promotion, if it is a question of opportunity, if it is a question of education, gender cannot play a role. Therefore, the irrelevance of gender is self-evident. And therefore, equality is necessarily a mandate which has to be achieved in that particular context. Yes or no? Okay. But, if you believe in gender-specific spaces, and you also believe that the concept of body dignities vary between genders, what a woman is comfortable with, a man may not be comfortable with, and vice versa. That is a fact. What can put a woman to shame may not put a man to shame. That is a fact. Notwithstanding your attempts at trying to destroy every distinction possible, including a logical distinction, this is a fact which you cannot run away from. Because if that is the argument, then be it in airports or in the Supreme Court, you cannot have the parda where the woman is being screened and frisked. I'm sorry. Because according to you, they are all equal. And it shouldn't matter who is frisking and what is the gender of the person who is frisking and screening. A man can do a woman can do a man. Fair enough? Are we okay with that? So the point that you have to recognize is, when you start with the assumption that every person is equal, that is good. But the quality of every person's thought is equal is necessarily stupidity. It is a position that is born out of ignorance. Because then you are saying a broad-minded approach and a narrow-minded approach are effectively the same on the benchmarks of quality, on the benchmarks of value addition. Respect somebody's right to hold an opinion cannot be extrapolated to say respect every nonsensical opinion that comes out of his blessed mouth. That's difficult. And that is something that is difficult to accept and agree. You don't need to be a lawyer to make this point. You just need to believe in common sense to make this point. But that is an uncommon commodity, so I understand. It's difficult. It's precious, and it's precious little. Now you have to understand a few things. If the Constitution is to be treated as a transformative document, and it is treated as a document, so in the judgment relating to section 377, this phrase was used, the doctrine of progressive realization of rights. This is what they used. And this judgment preceded the Sabarimala judgment. The moment this doctrine was introduced in 377, I knew what the outcome was going to be in Sabarimala, because I saw where the Supreme Court was going in that particular direction. It was very, very clear. Because the doctrine of progressive realization of rights allows the body to keep changing the rules as it goes along, and to keep making up the rules as it goes along. It also allows the body to create more rights, which is why you have about 17 to 19 rights as part of Article 21. That is the positive side of it. But what is the negative side of it is unrestrained judicial activism. What happens is a body over which you have zilch control, right from appointment to remission of office, including promotion, and who gets to be part of the particular collegium, and who gets to benefit from the decisions of the particular collegium, will ultimately decide how this particular book or this instrument is going to be interpreted for all time to come. Therefore, in a sovereign republic which has put its faith in democratic ideals, has decided to surrender all its logic and its future in the hands of a handful unelected people. Okay, let's put it this way. How many of you can confidently say, based on your knowledge of law at this point of time, that someone who's an expert in taxation will equally be an expert when it comes to intellectual property law? Can you make that statement? Is it possible? Can someone who's let's say expert when it comes to Hindu law, can he immediately claim that he's equally an expert when it comes to Muslim personal law? Not possible. So is it possible for one particular person with a general qualification to treat himself or herself or himself as the last word and the fount of all wisdom when it comes to every religious practice? Within a certain community itself, when there is a diversity of practices, can you be an expert with respect to every set of practices? You need a handwriting expert to look at issues relating to handwriting. Why aren't you looking at experts when it comes to issues relating to religion? Because you cannot claim to know everything under the sun. It is impossible for anybody to make that statement and get away without invoking guffaws and scoffs from the audience. Even within intellectual property, someone who is an expert in trademarks may not be an expert in copyrights, may not be an expert in patents. That is the wide distinction, particularly when it comes to the subject. Therefore, nuance is the name of the game. So if you dumb down the level of the discussion of the discourse to the kind of discussion that happens on prime time news channels, then effectively you might as well throw your legal degree into the dustbin. Because you're no different, and you don't need the legal degree to make those kind of arguments at all. There must be some distinction between someone who wears the black coat and reads a document which is written in black and white and someone who doesn't wear it. Because then it becomes the responsibility of people who wear the black coat to try and explain to others what is the nuance which they fail to understand. Then the argument that comes from the other side is, Arey bhai, but law is something that every person is supposed to understand and is supposed to know. That's a stupid argument according to me. Everybody uses phones. Do you know how the phone works? Do you know what is the technology inside? Do you understand the concept of a radio frequency baseband processor, which is the chipset in which all primary technologies reside? Are you aware of this? A phone must be user friendly. Doesn't necessarily mean that the technology must be known to the person who uses the phone, because all you are concerned with is the interface that you interact with, right? That's it. So if you try and take away nuance completely from the concept of law, what you get are a few buzzwords. Patriarchy, feminism, gender justice, gender discrimination. I am not going to make a mockery of the concept of equality, nor am I going to make a mockery of the concept of gender justice. They are relevant, they are valid, they are necessary. I knew the kind of trolling I would be subjected to when I decided to take that particular position, but I knew what I was talking about, and therefore I had absolutely no problems taking the position at all, because I've read what I'm talking about. I've read the subject, I've read the scripture, and I've applied the four corners of the Constitution to the text of that particular practice of the temple. One, I did not want to comment on this particular issue because the review petition is sub judice. But this is an impressionable audience, and if I don't respond, it would seem as if I don't have a response, but I do. Therefore, I will give the response. One, it is not based on menstruation. It is not at all based on menstruation. This is not intellectual chicanery at play. This is not, I'm not being a charlatan and I'm making the statement. When you say it is based on menstruation, then you have to prove that it's based on menstruation. But if you don't prove it, doesn't mean that you've proven the converse. Apply principles of evidence. Sorry, you're talking about a legal issue, please apply principles of evidence. The one who makes the claim takes upon himself the burden to prove that particular claim. If you have not been able to establish using a single document that this is based on menstruation, then you don't have a case. That means you have misunderstood the entire case altogether. I will address this issue before I blow up the issue. Now, point number one. He is not a brahmachari. He is a naishthika brahmachari. There is a difference. Half the people in the country who have read this particular issue don't even understand the word, they don't understand the phrase. Because you are not meant to understand it, this is not something that you have been trained in. Therefore, if you don't know what you are talking about, the golden principle is zip it. You are entitled to have an opinion, but it's not your right to hold an uninformed opinion and foist it on others. That's the difference. Okay? Now, Naishthika Brahmachari means, the root word comes from Sanskrit as well as Hindi, Nishtha. From Nishtha, the noun form becomes Naishthika. What is Naishthika? There is a Brahmachari, there is a Naishthika Brahmachari. Apply simple rules of syntax and grammar. एक noun हो गया तो दूसरा adjective बन गया ना. Therefore, the adjective must inform the noun in some way or the other. If Brahmachari and Naishthika Brahmachari are the same, why do you need a Naishthika Brahmachari at all? Then there is a redundancy. The word for that in English is a pleonasm. Pleonasm means two words meaning the same thing which need not be used together. So why do you need a Naishthika Brahmachari? The concept is this. It's not about hatred for women. What people have not even asked themselves is, can a woman be a Naishthika Brahmacharini? If yes, what are the rules that she is supposed to follow with respect to her contact with the opposite gender? That's a question they've never asked. They've almost made it sound that this is a male specific concept. Naishtika Brahmachari means simply this. So, unfortunately, since the understanding of Hindu law in schools is reduced to matrimonial disputes and succession, you may not know beyond this, so let me try and help you with that.
What is the meaning of this word?
Let me explain this, I'm coming to this. There are 4 ashrams when it comes to the Hindu way of life, right? Between the ashram where you are a student and then you get into the householder ashram, which is the grihastha ashram, there is a transition phase. That is where there are 2 forms of brahmacharya. One is called Upakurvana brahmacharya, the other is called Naishthika brahmacharya. Upakurvana brahmacharya means what? As long as you remain in the Gurukula, you remain a brahmachari. What is the traditional logic? Simple logic. Okay. The moment you get out of a particular place, you are no more a brahmachari. Your hormones are set full, they've given complete range. You've come out of it. But when you are a Naishthika brahmachari, you have taken the vow that for the rest of your life, or the Guru's life, you will continue to serve the Guru in his particular ashram without getting out of that particular place as a student for the rest of your life. The student form of celibacy you have taken upon yourself for the rest of your life. So what happens if the Guru passes away? You serve the Guru Mata, his wife. What happens if the Guru Mata passes away? Then you serve his children. What happens if they pass away? Then you serve fire. That means you will lead the life of penance for the rest of your life. That is the concept of Naishthika Brahmacharya. Which doesn't mean Samne Apsara agi ab ladka aa gaya. Ye nahi hai. That is not the concept. The basic point is this. The basic point is, I have these rules which I have to observe. Now if you tell me, तुम कौन होते हो इसको observe करने वाले? मनुष्य के पास right to privacy हो सकता है, भगवान के पास नहीं हो सकता है. A temple is not your home. A temple is his home or her home. It is his or her abode. It is not a place of prayer or congregation, at least as far as Sanatana Dharma is concerned. It is a place of worship. There are several rules that are followed. I am going to quote an example that I've heard often, and it's a very popular example and a very logical example. When a fish lives in the ocean, usko dana dene ka theka aapne nahi rakha hai. You have not decided to give it food, it will live and die on its own. But if you choose to rear that fish in an aquarium in your house, then you have to take care of it. That is the difference between God and deity. Unfortunately, we don't understand it because we are a deracinated lot. So what to do? Now, at least do we have the decency to say, there may be some things that I may not understand because I don't relate to them. Therefore, I need to be very, very careful in my ability to comment on that particular issue because I know that I do not possess the skill sets required or the knowledge required to comment on that particular issue. People ask me, the way the news reports reported this, it was almost as if Ayyappa came there saying, very brahmachari ko bacha lo na, please, please. No, that's not what happened in the Supreme Court. What happened in the Supreme Court was this. The deity, according to us, is not a figment of imagination, but is a living creature, is a living being. That is the belief. पत्थर जब मूर्ति बनता है, then एक transition होता है. That is the basic concept of idol worship. And when that happens, you have chosen to follow certain rules. Are you going to sit and apply secular logic to a place of worship? I'm so sorry. Then how are you absolutely sure that a deity sitting somewhere, God knows how many light years away, is going to be happy with the head of a goat? Are you sure of it? Why only a goat? Why not an ant? You don't know these answers because the luxury of being someone who is an anti-theist or an atheist is that he has no skin in the game. And therefore he has decided to take upon himself the ability to comment on everything under the sun and saying everything is equal because everything is BS. The problem with that is, you don't know what the sentiment is. You don't know what is the concept of desecration and consecration which the believer puts faith in. Therefore, you are in no position to comment on it. I will never fear the rabid, religious, dogmatic fundamentalist. I will always fear the person who says equality is everything because he is going to destroy everything under the sun without understanding anything under the sun. So, no, not to you. I'm generally talking. It's a general point. No, due respect, I am not being sarcastic. As far as I am concerned,
you have still not explained what type of...
So, let me answer that question. I understand, sir. Perhaps I am being unclear, but I will answer. So what has happened is this. Sir mentioned excreta and urine. He's absolutely right on that count. But the logic needs to be taken a step further. The reason why a woman is not supposed to enter that particular place of a procreative age group is this. This is the belief in Tantra Yoga. It is a tantric temple. It is not a temple that is based on Agama Shastra, which applies to every other temple otherwise. In tantric temples, there are 3 bodily fluids which play an extremely important role. Urine, semen and blood. Okay? What is the meaning of this? Am I inventing all of these rules? No, there are scriptures for it. There is commentary on this extensively.
Semen and blood.
Urine, semen and blood. So chapter 10, verse 2, I'm not being Zakir Naik here, I'm sorry, I'm just telling you something that is legitimate, okay? So chapter 10, verse 2 of a treatise called Tantra Samuchaya, which is a treatise written in the 15th century, which applies to tantric temples and their traditions, specifically says that these 3 fluids are varjit as far as that particular temple is concerned. So what is the consequence? Let's play this out. Read the notifications of 1955 and 1956, which contain the age prescription of 10 to 55. They specifically say, bearing in mind the specific prana pratisthana of this particular murti, of this particular idol in this particular temple, blood in any form is actually prescribed. That means a wounded man or a bleeding woman cannot enter. It applies to both. I have been to the temple as a 13-year-old. I walked 62 kilometers. If I had suffered a cut as a consequence of walking through the 7 forests and entering that particular temple, until that cut is healed or it is tied, I cannot go into that particular temple, even after having observed 45 days of strict vow. That is the rule. Nobody has actually discussed this at all. All of this is available on my written submissions on the website of People for Dharma. Please go and read it. What I submitted by way of written submissions before the judgment, what I submitted by way of review petition and written submissions supporting the review petition, all of them are available. Please read it. The thing is, we form our opinions through NDTV, which is perhaps not the best source. So the point is, what happens is, the point I'm trying to make is, this is the basic logic. Now, is it meant to protect the brahmacharya of deity or the woman who comes in? Now here's the belief that plays an important role. You're adults. Phallus as a concept you understand. Phallus moves upward. Correct? Hopefully. Right? The energy of a woman who has a procreative age group moves downward. Because that is the movement of the blood when she is going through that particular cycle. What is the belief? That the energy of a brahmachari who is an eternal brahmachari in that particular status is harmful to the energy of the woman, therefore it affects her uterus, and tomorrow when she decides to have a child, it will be a deformed child. It's the basic understanding, that is the basic belief. ये क्या science है, ये तो superstition है. Religion में superstition क्या है, religion क्या है, बोलने वाले आप कौन होते हैं? That is for people to decide. You have no skin in the game, you have no dog in the race. Then you stay out. You don't believe in it. You don't subscribe to it. Then you don't have the right of access. I'll just take 30 seconds and finish this off. Please go and read this. I've said this extensively. Unfortunately, the thing is, I don't think people have bothered to read or even understand because arguments tend to be predictable and unimaginative and they walk the same trope. Now, on the issue of faith versus state, Sabarimala is just a symptom. It unfortunately, because it happens to be a sensational symptom, people focus on it. But you have to look at it differently. What are the issues that affect this particular question and that flow from this issue? 1. Does India have a religious identity is the central question that you have to ask yourself. Because from there flows the concept of secularism. Second, secularism as invented during the process of enlightenment and secularism which the British chose to bring into this country are 2 different things. Because in enlightenment what they said was, when 2 different denominations are fighting, the state should not take the position or the support of a particular denomination, which is to say, the Protestant will not be supported against the Catholic by the state. That is how secularism was actually evolved. When secularism was brought into this particular country, it was almost like a Pakistan-style argument, which is, the missionary groups were to be treated as non-state actors, and therefore the East India Company could say, I have nothing to do with their activities, let them do what they have to do, I will not interfere with it. Therefore, the separation of the church from the state facilitated the activities of certain groups who did not want any further interference from the state at all. Therefore, the state could say, I am not involved in this at all. I will continue to swallow your country step by step, and I will also swallow you culturally and religiously, but I have nothing to do with this particular entity because I have separated this organization from myself. That is how it worked. Secularism, as Dada rightly pointed out, came out through the 42nd Amendment in 1976, therefore it was not in the preamble. What was the date of the delivery of the judgment of Keshwarata Bharati? 23rd of April 1973. So when the basic structure doctrine was evolved, secularism was not in the preamble. So is secularism part and parcel of the basic structure of the Constitution? Ask yourself this question. 3. If secularism means separation of the church from the state, is it okay for the state to say that I will control the funds and the outflow of the religious institutions of one particular community? In which case, what happens in a situation where only the temples are under state control? These are multiple questions. Ask yourself. You'll get better answers in the Asatoma petition, which will come up for argument before the Constitution bench. Let's hope I have an opportunity to argue there as well. Thank you.
Very strong debate. I think this first, I think Professor Dixit wants to have his response. Welcome. But I would again request, no problem, we should all take our time and ensure that we get through.
Very prayerfully, his speech was very spirited, but the logic or the argument I have not been able to understand so fully. Well, he has given so many arguments. And the most important was that the deity practices a different sort of celibacy, in which the presence of semen, blood, and urine are not allowed. And the rule has been made that men can come, but the woman between 10 and 50 cannot come. And the touchstone is semen, blood, and urine. The rules are made by them. That is, rules are made by patriarchy, not by matriarchy. I do not mean to say that men and women shall be treated similarly. There are bound to be differences. But the differences must not be such as to lower the dignity of the woman. That is very important. The moment dignity of one gender is lowered, it amounts to violation of equality. No one says that equality means similarity. Then as far as these rules are concerned, on the touchstone of semen, urine and blood, they do not prove to be logical. Because if blood is to be allowed, the rule should have been that the women, when they are not during the period of menstruation, should be allowed to come. Number one. Number two, under these circumstances, all men between 12 years of age and 80 years of age should not have been allowed. Because there is potential problem of ejaculation of semen. There may be some drops, apart from urine, which is common to men and women both. So the point is simply this: the rules are made by those who wants to humiliate women. That is the only important thing which I want to tell. You. Right? I'm responding to him.
Debate has been very heated. That's an understatement. So, but what I would like to do, I'm sure that out of this entire audience there would be people who would contribute to either views. That's a wonderful thing. In a debate like this, it's wonderful that, and I always tell people this, that the great thing about legal academia is that you get to read. I think when we stop reading, whether it be things which we agree with or things which we disagree with, that's the end of the debate. And this is something which I tell all my juniors, and I will share with you, that the moment we think that an argument is beyond the pale, that an argument cannot be made, then we shut ourselves. Every argument, wonderfully, I think this was an incredible debate, and I don't think something like this will possibly ever be recreated. It's a wonderful debate of two radically different interpretations. And I think I have been greatly privileged, and I think all of us have been greatly privileged in seeing these wonderful two radically different views colliding with each other, and to that extent has shown us light in what we think is true to ourselves, because what is true for each one of us, to me, is different from what is true to the other. So, keeping all this in mind, and keeping in the spirit of this wonderful debate that we are having in mind, I'm throwing this question in case, are we taking any questions? Oh, terrible. It would have been wonderful if we could take questions. But in the end, I think there is nothing more to be added. I think in the end, I think that I would like to thank both Professor Dixit as well as Sai Deepak for this great and wonderful debate that we've had. It's been a privilege to be here, and I think both of them have encapsulated what they wanted to say. And thank you all for being here. It's been such a pleasure to be here, and speaking for myself, and I'm sure speaking for the rest of us. You've given us an extremely patient hearing, a very receptive hearing, and you've been a wonderful audience. Thank you very much.
I'd like to request Professor V.K. Dixit, who's been a panelist with us as well, on behalf of the university, to please give a token of appreciation to the two guests for today.